The next part of the framework is intellectual property, and it's really important that providers understand this. So much so that we invited Wayne from HCR Law to come into the CPD-TD studios to discuss this with us.
So you'll find that I, within our accredited framework, is specifically about intellectual property. It's a very, very important area. So Wayne, let's get stuck into this, shall we?
Sure thing. Yep.
So intellectual property, what is it?
It is the expression of original thought. That's essentially what it is. And it falls in broadly into 4 categories. So you've got copyright, which covers written content, musical works, artistic works, and sound recordings. Secondly, you have trademarks, which cover names, logos, brand identifiers, such as Nike or McDonald's. Then you have patents, which cover broadly inventions. So that can be physical inventions like a mousetrap, or drugs in the pharmaceutical space also qualify for patent protection. And then lastly, we talk about design rights, which are a form of copyright or an extension of the copyright body, but they cover design features of physical products. Those are the 4 main areas of intellectual property. And like I say, the key thing to remember here is that intellectual property is intended to cover the expression of original thought. So it needs to be manifested in some way, whether that's in writings, like say sound recording, the logo committed to paper, or the invention put down and recorded as a form of a registered patent. What intellectual property law doesn't cover is thoughts in your own head when you keep them to yourself. They're there, great, but you'll only afford yourself protection once they're committed. So like I've just touched upon, some areas of intellectual property operate under a registered system, some don't. And probably most relevant to this conversation is copyright and the content that your trainers are creating when they're delivering their courses. And copyright in the UK operates under an unregistered system, which means that there's no requirement to go and register copyright with any body, such as the Intellectual Property Office or anything like that. You're afforded that protection as soon as you put pen to paper and share those that material. The same goes for sound recordings, video content. As soon as it's created, you're afforded that protection, and effectively you're given the exclusive rights over the use and exploitation of those creative works. Lots of the listeners to this podcast will be familiar with the copyright logo.
Yeah.
And at the bottom of websites or printed materials, we often see copyright protected and then a year. That doesn't afford the copyright owner of those works any more protection. It's simply a warning sign to others that this content is copyright protected, as soon as it was created, as I said a moment ago, and warns others off from potentially copying it without the owner's permission. So that's one step that people, copyright creators can adopt. But I think that one of the most important things to ensure here is that when content is being created by your training providers, it is either original content that they've created, or if they are using other people's content, taking content off the internet, for example, that content is either open source content, where you don't need a license to use it, or they've acquired the appropriate permission of the copyright owner to use that and exploit that copyright content. Without that permission or authorization from the copyright owner, your trainers potentially face the risk of copyright infringement action, which broadly speaking amounts to an allegation that you've copied their works without their permission and you've derived some kind of financial benefit from doing that. And so the copyright owner may be entitled to seek an injunction, so a prohibitive injunction preventing your trainers from using their content again. And secondly, and possibly more importantly, either a damages claim or an account of profits. So forcing your trainers to account to them for the profits that they've generated from using that copyright protected material without their permission.
We've seen training manuals sent to us where every piece of it has been, I mean, you simply Google a sentence from it and you'll find the original works online somewhere. Okay, and the whole manual is made up of various different articles from different authors all over the world. You know, so technically the content is fantastic. The learning journey is really good. That's because it's been essentially written by the best doctors or the best people in the world, you know, this kind of thing. But can I just tweak the words a little bit, change a little bit here, there, and everywhere, and it still becomes my own?
Okay, so we're getting into the weeds here of copyright infringement. But I'll try and explain this as simply as possible. But the courts tend to adopt a qualitative rather than a quantitative approach.
Right.
So what I mean by that is if you take a page of written material and you divide it up into 5 paragraphs, if a training provider takes a paragraph from 5 different sources and pops it into one document, that training provider will have infringed the copyright belonging to all 5 of those original authors. If they take a piece of A4 paper, written prose, and you change all of the sentences slightly so that it reads slightly different, or there's a creative element or input into creating something new throughout the document, then you're less likely to infringe. Okay, now if you only change 1 or 2 words and the overall structure of the sentences and the messaging remains the same, then you're pushing towards infringement.
So ultimately, the main advice is make it original to start with. Is that
yeah,
fair to say?
It goes back to my very first point. Intellectual property protects the expression of original thought. So if it's your own work, then you're fine. I should say that you could have 2 training providers delivering the same kind of course on the same subject matter, sit in 2 separate rooms and create identical training materials. Because of their experiences, their training, where they went to school, all the rest of it, they just happen by pure coincidence to create something identical. They will both be entitled to copyright protection over their own materials.
In terms of licensing as well around this, so again, when our manuals come to us, from our training providers who submit them for accreditation, there's written content, obviously, but it's generally supported by imagery. Now, we've seen on many occasions, which we've had to send back, people using images with Shutterstock watermark right across the middle, which implies to us that there's no license behind that. Now, do people need to have these licenses in place? And if so, what are the implications if they're using these images without that license?
Okay, so I touched a moment ago about obtaining the copyright owner's consent authorization to use their works. And that's effectively what we're talking about when we talk about licensing, copyright licensing. The most important thing to ensure here is that that license, if it's been obtained, is in writing, and that it provides your trainers with the right kind of license. So the ability to use it for training purposes. So licenses are often bespoke and give the licensee rights to use works in specific instances or for a specified period of time. So because a training provider has a license in place, it doesn't necessarily mean that they've got carte blanche to use that material in any way they want for whatever period they want. So it's important to look at the terms of the license. But fundamentally, the point you're touching on is without the copyright owner's permission, use of that content constitutes copyright infringement. So it is vital that permission is obtained in the form of a written license.
So you mentioned as well in terms of licensing about open licenses or open source licenses. I'm not sure which way you phrased that. I mean, what does that mean?
So there are certain instances where copyright creators are happy for the world to use their content, and they put it up online, and then be some specific wording around that content which says that anybody is free to come and use it. So they're effectively giving a license to the world to use their content. And there are specific websites that you can go to which has content on there, and photographs and things like that, where you're free to use them without paying any kind of license fee or obtaining any additional authorization.
Right, that sounds very similar to, a course came into us, after the COVID period, that kind of thing, and they were using NHS imagery and, statements from the NHS websites and things like that. So when our assessment team looked into it, there was actually an open license, but what they requested is that you referenced it in a very specific way. And this individual who'd sent us the application hadn't referenced in that way. Does that mean that piece is then, infringing upon copyright because they've not done what they've been requested to do?
Yeah, in all likelihood, yes. And it comes back to this point about the scope and the terms of the license. So what we're talking about there is not strictly open source in the bare sense that we were talking about a moment ago. That permission for others to use that content was conditional, and without those conditions being met, as you say, use of it would have amounted to copyright infringement.
Yeah, it's really useful to know because we do see lots of people using that kind of open source. The way you've described it, it sounds very much like the information that people are using, but making sure they protect themselves on those conditions is highly important. If you were to give one solid piece of advice to people out there who are writing their own educational content for their training materials, what advice would that be other than originality?
I think if you're running a business where there are one or two individuals creating the content and you have effective oversight of all the content being created, that's a fairly straightforward situation. I think the problems come when your organizations grow and you have teams of people creating content. And and that's where companies can run into trouble, where parts of the business perhaps aren't properly educated around this stuff, around the intellectual property, and ensuring that they're not infringing, they're not taking content from the web without copyright owners' protection. So I think my main tip in a very convoluted way would be to ensure as your business grows that training, proper training, frequent training is rolled out to everybody that's creating content so that you don't run into any of the problems that we've talked around.
So imagine, I'm just putting you on the spot here, Wayne. Imagine I've created a new original training manual, using it to train lots and lots of different learners out there. One of those learners then takes that manual, puts their own brand on it, and starts using it as their own. How do I protect myself in that instance, and what can I do about that?
Okay, so protection, as I've already talked about, there is no formal register in which you can protect your copyright. So one of the ways of warning others off from copying or infringing your copyright is to put the copyright logo that we know so well at the bottom of all the, possibly on every page of the manual if necessary, but certainly on the front and on the inside cover. And then if infringement does happen, then the first thing to do is speak to an intellectual property lawyer about potential action against that company or individual that's used your content without your permission. But ultimately, the two things that the law entitles you to do is to seek an injunction to prevent them from continuing to use your material, and damages or an account of profits. Account of profits is probably more preferable if the party that's infringing has generated significant income from using your content.
Have you got any final hints and tips that you would give in relation to IP, just in general?
If in doubt, speak to a qualified intellectual property specialist. Today on this podcast, I've run through some broad principles around specific copyright infringement or authorizations to use copyright materials. But IP is a specific area of law, and there are lots of exceptions and nuances to it that layer on top of the basics that I've set out today. So it's often dangerous to assess a situation or proceed. If you're unsure, always go and speak to a lawyer, because they'll be able to give you that certainty and ensure that you move forward with your business on a sure footing and you're protected against potential, adverse legal action, which can, drain on resources, both time and financial, for any business. And quite often the advice will be quite straightforward, and the steps that you can take to protect yourself can be fairly minimal. The dangers arise when you potentially head on the wrong path or use infringing content for a period of time, generate significant profits as a result of that use, and then face significant legal action. So, in a very convoluted way, my key bit of advice was to seek advice early.